G'day everyone, welcome back. Lovely to have you here on the show today. It's the 15th of October when we're recording this, but who knows when you're listening to it, probably not too long after that. Today we're going to be talking about something that I've actually not encountered in my 20 years in mortgages, and so it's always exciting for me to find new things that can have a really positive impact. And the context is perhaps something that we don't think of as positive, which is when you have relationship breakdowns and properties are involved. And so today, I want to welcome to the show Ian Macleod from a company called RP Emery Associates. We'll talk a bit about them in a sec. But firstly, Ian, welcome to the show. Bit of introduction about yourself, and then we'll dive straight in.
G'day, Vincent. Thanks for having me. So we are RP Emery Associates. We're a legal publishing service. Full disclosure up front, we are not a law firm. I'm not a lawyer. So please don't take any of the information you get from me as legal advice. But we have a bit of a niche market where we help people through situations where they might be separating and they need either a binding financial agreement or court orders. I should re-preface that we don't help with court orders, but when people are separating, they have a choice. They can either divvy up their property using the court system. So essentially, a magistrate looks at who contributed what and what you've got in the property pool, and the magistrate decides, all right, you get that and you get that. Okay, it's a long and painful
And
situation to go through, and extremely costly. I wouldn't really wish it on anyone. And I've fortunately, touch wood, I haven't had to go through it myself, but I've witnessed thousands and thousands of matters where people are separating. And so you have a choice. You can either go through the court system, or you can make a private agreement between yourselves known as a binding financial agreement, which essentially sets out how you are going to divide your assets and liabilities.
Okay, understood.
Okay.
Yeah, and okay.
Yeah, and quite often when people are dividing their property, there'll be real estate that has to be dealt with. That real estate may be transferred from one party to the other and some money changes hands, or it might be a case of the property is sold and the proceeds divided, or there might be multiple properties.
Right, okay.
Yeah.
Yeah, and so I think I want to cover this into two buckets because I think there's two types of things we're going to talk about, and they're both covered under private agreements, but let's separate them out for people. One of them is the case where you have already, separated, or that is happening, and it is already understood or agreed as to who is getting what, but that there is a financial impact to you from transferring part of a property that is part owned by one person to be fully owned by the other person. So that's one bucket of problems, if you like, and there's costs associated. So we'll talk about that. And then the other one is maybe you're coming into a relationship, or maybe you're in a relationship and you know it's not going well and you want to part on amicable terms and you want to come to an agreement as to what you are going to do. So let's talk about those two buckets separately. Let's firstly talk about the things already happened. You own a property together and you want to get it from one person to the other, and what the problems are and how private agreements help to deal with that.
Okay. So whenever, let's take an example of a couple who own, they've been together for 20 odd years. They have raised their kids together. They own a house together, or they might own their house with the bank. And the issue is, one party's either going to either retain that property or they're going to sell it. In the case where one party is going to retain that property, quite often they'll have to go to the bank to get a mortgage, all right, so they can pay the other party out, all right. And when you transfer your interest from one party to the other, you will normally incur stamp duty. right? And stamp duty, as you know, can be significant. The average price of a property in Sydney is what, I don't know, $1 million thereabouts at the moment, right? So if you have a $1 million property and you're going to transfer that, you're probably looking at $50,000 of stamp duty that you would have to incur, unless you have a binding financial agreement in place or a court order. So if you have a binding financial agreement, you can sidestep that $25,000, and quite often the banks will insist on some sort of an arrangement, either once again by court order or a binding financial agreement, that finalises the financial relationship between the parties, because they don't want
to the
to,
property,
with respect to with respect to all of their assets and liabilities. That includes superannuation, cars, motor vehicles, business interest, all of it, because the banks don't want one party coming back later on for a second bite of the cherry, So they like to see they want to make
clarity.
sure that they want to make sure their interests are protected, and that the parties themselves can move on with their lives independently.
Understood. Okay, so that's one bucket of things where essentially it's hey, you guys are both okay, you're amicable, and you've essentially agreed in terms of what legally you would call a meeting of the minds, right? So you're both
Correct.
happy as to what's going to happen.
Excellent choice of words.
And thank you very much. It was my business law minor from 1995. I do remember the three things required for a contract, and I know that's one of them. But the private agreement is a formal way of articulating that is then acceptable both to the parties, but also to external parties like a bank who has a mortgage or is providing a mortgage to buy the party out. And so, in that, just as a quick tangent on that, so RP Emery and Associates, as what you call a legal publisher, did I get that right? That term, have got a template and a document that has all the right wording and verbiage and articulation in it, so that you can document that correctly and to the level which other people would then be, that ticks all the boxes.
Yes, that's correct. One important point: before you sign a binding financial agreement, both parties must receive independent legal advice. So you must have two independent lawyers, one to advise each party. You can't have one lawyer, because that lawyer would have a conflict of interest. Okay, so must have two lawyers who then would provide a certificate that says, I've provided certain advice to my client in relation to this document, in order for that agreement to be binding. Binding meaning that if one party doesn't honour their obligations, right, something runs off the rails, then you can present that document to a court and have the court enforce it.
Understood. Okay, wonderful. Okay. All right, so we've got one bucket. Sorry, keep going. Was there anything more on that?
Yeah, that's all right. So even though we're a legal publisher, I have a relationship with a number of lawyers who can provide that legal advice in relation to a document that you've drafted from our kit. And essentially, the process is that you draft the document from the kit, send the document back to us. We then prepare that document for the lawyers so they can work within this fixed fee structure that we have. Essentially, we have to knock all the bumps out of the road to make the lawyer's job easy, and smooth the path, as it were.
Yeah, and it's a BYO lawyer thing, though, right? So if you say this is the family lawyer I want to work with, then they will get a finished version of the document that says, great, well, you and the other party seem to have agreed to this. I'm now going to act in your interest to say, should you be agreeing to this? I'm going to, checks and balances from a lawyer perspective on the agreement that you say you're comfortable on. I'm going to give you a second opinion. It's essentially what's happening.
Yeah, essentially, under the Family Law Act, the lawyers have to provide specific advice, and that advice is, first of all, do you know what your rights are, all right? And people separating, whether it be a de facto relationship of sufficient duration or a marriage, you have access to the court. You have access to the court system where a magistrate could make a decision about how your property should be divided. But once you sign a binding financial agreement in accordance with the Act, so you've received that legal advice, right, and you then sign that document, you essentially close the door to the family court. So you can't bring an action in the family court after you've signed the binding financial agreement. So that's one aspect the lawyers have to make sure that their client understands. And the second one is the advantages and disadvantages. So the lawyers have to explain to their client whether or not this agreement is to your advantage or to your disadvantage. That is it a good deal for you?
Got it.
All right. Should you be asking for or renegotiating your position after you've received that legal advice, or should you just be happy that you've received that advice? Right. You don't need any further amendments. Sorry, I was just distracted by somebody coming up the driveway with a large piece of machinery that I hadn't ordered.
Wonderful. So, we'll find out about that in about 15 minutes.
Yeah, probably a bit sooner. All right.
Okay, cool. So we've got private agreements, and I've got some general questions about private agreements, but I'll save those to
Please
the end.
do.
So the other bucket of things is where someone is coming into a relationship and are thinking, look, hey, and in fact, one of my friends, I actually had coffee with him just a month ago, and he was going into a new relationship, and his partner, she had a couple of investment properties and he had no property. And they were fairly early in their relationship. They were only, I think, 3 or 4 months in.
Yes.
But she presented a financial agreement and said, I need you to be comfortable that whilst we're going on this journey together, I'm not risking these assets. And I think it had come out of the fact that she'd been in a previous relationship. I don't know that for sure. So it's really, really interesting to see that in play. And I have no idea how he approached that or where that agreement came from. But this is the other bucket, right, where an agreement is used to provide the baseline for how the parties agree to act if things don't work out at some point in the future with respect to specific assets or all your assets, or how does that typically work?
Typically, and the parties themselves have full control of what the document actually has to say. But typically, we would separate. We would identify separate property. Right. So here's an agreement that says this is Party A's separate property. This is your superannuation. This is your real estate. This is your bank accounts. All right. Separate property could also be any inheritance that one party might receive. It could be a windfall of some sort. It could be interest in a trust or interest in a company. So we define separate property as all of these things. Essentially, if it's in your name and it's on title, then that's your separate property. Joint property would be defined as anything that you already own jointly and you identify in the contract. And if it can't be identified as separate property, then it becomes joint property. Does that make sense?
Okay. Yep. It's either all of this or it's that. Yep.
It's either this or it's that. It's either separate or it's joint. And the basic agreement says that in the event, if there's a breakdown in the relationship, Party A keeps their separate property, Party B keeps their separate property, and any property that you might have bought together or you owned previously or own in the future together, you would divide that in proportion to your contribution. Yeah. So it might be 50-50 or it might be 70-30, whatever the case may be. All right. So it leaves things nice and clear and tidy and gives the parties some ground rules to work with. Get you out of court.
Yeah. And so a couple of questions in this. So, I mean, I'm guessing the answer is going to be pretty broad, but who typically could or should consider one of these in terms of types of couples? Is it just for people with tons of assets, or is it for everyday Australian? Like, is it like, help me understand that?
It's for anybody who feels insecure, I suppose. All right. I can't tell people, like you should get one of these or you should not get one of these or whatever. That's totally up to the parties themselves of what they should do. But if you're feeling insecure about entering into a new relationship because you understand that once you've been in that de facto relationship for 2 years, then you have access to the family court. So if you've got a couple come together, all right, and once they've been in that de facto relationship for a period of 2 years, either party has the right to ask the court to make orders for the division of property. And when you make a binding financial agreement, essentially you just close the door to that court, right? So because you're saying to the system, we've already decided this ourselves. We received legal advice years ago, and you can't bring any action in the family court while this agreement is in place.
Yeah, and like if we just kind of you've taken it from a nice emotional angle, which is if you're unsure and you're uncertain or it's worrying you, then this is how you get protection. No different to how you might get an insurance policy because you're worried about hail damage or whatever else. But just taking from a pure economic argument, and you gave me a bit of a number before the show, say the cost of the agreement is somewhere around $3,500 for the private agreement itself and the templates. You've got to go out and get legal advice. So there's probably a couple of grand on either side for legal advice, but sub $10,000, right? For is probably what order of magnitude for someone.
Well, that might be if you went through the normal system where you go to a lawyer and say, "Here, I want you to draft this." They will draft the agreement, and then once that's all done, the other party has to take their document to another lawyer. Whereas with our system, I have a relationship with these lawyers that we work with. I've only got 5 of them, but I've been working with the same 5 for. The last lady came on about 10 years ago, so I've got good long-term relationships with them.
It's always good.
Sorry, I just lost my train of thought.
No, just trying to think the whole cost for the approach. Yeah.
So the whole cost, like through us, is going to be around about $3,500.
Oh, okay, including the external.
So that includes the legal advice.
Oh,
that includes the legal advice from 2 independent lawyers. Whereas I would encourage people to go shopping, and if they're interested in one of these agreements, go shopping. Try the normal system first and make the comparison. But at the end of the day, you finish up with a document which is as good, if not better, than what you would receive by going to a lawyer who is experienced in this particular area.
Yeah, understood. And so I guess the thing that I was trying to understand was if, in understanding who this might be useful for, if someone has more than $5,000 worth of assets maybe, or potentially, again, disclaimer, this isn't legal advice, or the cost of going and getting this sorted out if you don't put one in place is easily going to go over $5,000 after the fact, then the insurance pays for itself, I guess is the point I'm making.
Yeah, but I have an analogy here. All right, so
Please.
If something like 40% of first-time marriages fail within the first 10 years. So within the first 10 years, there's a 40% failure rate. Subsequent relationships have a higher failure rate again.
Really?
So, it's
that's actually surprising. I thought it would have been the other way around. I would have thought second go round, you're probably better at all this.
You would hope so, but unfortunately, it goes the other way. All right. So you have a house. All right. Your house is worth roughly $1 million, I suppose. You might have 2 or 3 houses. Okay. But you insure that house. All right. And I believe this figure is correct. Somebody might want to correct me. The chance of your house burning to the ground or being a total loss in a 10-year period is less than 1%.
Right.
Less than 1%. Okay. So if you're looking at purely from an insurance point of view, all right, a binding financial agreement is one premium that protects your whole financial security. All right. And if you knew that, you were likely to have a claim of within a 10-year period, you feel 40% likely to have a claim within a 10-year period, then it's a bit of a no-brainer, really. When we all insure our house, all right, when the likelihood is less than 1%.
Right. What's interesting
right.
about that, just as a home loan parallel here, is the bank actually requires you to get building insurance for your home because they want to make sure that they're not at risk. I'm surprised that they don't require you to have a binding financial agreement on the same basis.
Yeah. Well, I suppose
that would make your job a whole lot easier.
It probably would, but then again, you wouldn't have genuine agreement because you'd have the influence of a third party. All right.
Right. Interesting.
In order, like you said, in order for a contract to be valid, you've got to have a meeting of the minds. And if somebody's saying, "Well, you've got to get this," and they don't, well, we don't want it.
I don't want it.
Right? Then you haven't got genuine agreement. Yeah.
Hey, and we've talked about kind of the assets that might go into it. With these agreements and private agreements, is kind of can you use is a prenup a private form of a private agreement? Is that something different? Before I move to my question.
The term prenup is just an agreement made before marriage. All right.
Got it.
Pre-nuptial. All right. It's agreement made before marriage about how your assets and liabilities should be divided if the whole thing turns to custard.
So it's a form of private agreement.
Yeah, that's right. But it's just a binding financial agreement. So the terms are interchangeable. We're used to the term prenup, all right, but under Australian law, the correct term is a binding financial agreement.
Understood. And I guess where I was going with this was, are there things that you wouldn't expect to cover? Because we've talked a lot about assets and homes and other assets, great. But what about these aren't designed to cover things like parenting arrangements and stuff like that?
No, you can't include parenting arrangements in a binding financial agreement or in a prenuptial type arrangement. We often get people who, like, oh, look, we're going to have kids, and if the whole thing turns sour, I'm going to get the kids. He's not going to get the kids. He's got to pay child support, blah blah blah, or whatever. All right. These types of issues you can't include in a binding financial agreement for a number of reasons, but if it's a prenuptial type arrangement, the primary one is if you can't identify children, you can't put them into
adoption. If you haven't had children yet, you can't put them in.
If you can't identify them, you need a name.
They can't be jointly owned.
Yeah.
And you can't sell them, I don't believe. So
no. I think there's laws against that somewhere.
Pretty sure. Okay, good. So, one of my questions was about enforceability, but it sounds like they're enforceable as soon as they're signed, assuming that they've been done in accordance with the regulations, which is external legal advice. They can't be done under duress and any other things.
That's correct. Yeah.
I want kind of the question I always like to ask about things like this in terms of what is and whether this is inside the framework of the agreement or more broadly. What does it look like to do this well as a couple, and what does it look like to do it badly? Because I think, and the reason I'm asking this is, I think there's a lot of stigma associated with taking this kind of step, and you will have encountered this where someone says, "I'd like this," and the other one says, "Well, I don't think that's in the spirit of our, loving matrimony." And like, how does this look?
Sometimes you do strike that where one party is feeling insecure. Right, they need the security of an agreement so they know that their assets and liabilities are protected, and the other parties might be saying, "Oh, well, you don't love me because you need this agreement." There's really not much you can do unless you have, as you say, a genuine meeting of the minds. So you've got to have two people, one that that recognises, okay, in order for our relationship to evolve, I might just have to go, yeah, look, I understand you've worked hard for what you have, all right, that's important to you, all right, and I'm happy to provide you with that security. If this is the way it needs to be done through an agreement, then let's go ahead. All right. But if you've got two parties who are one party really wants the agreement and the other one doesn't, then what's going to happen is you've got to get the legal advice in order for that agreement to be binding. And so the party who doesn't want the agreement, the first thing their lawyer is going to ask is, are you happy with this? And if they say, well, no, I'm not happy, I feel like I'm being pressured or I'm being coerced, I don't really want to enter the agreement. Well, the first bit of advice that lawyer is going to give them is, don't sign the agreement.
Mm.
Right? Yeah. And then and then you've got a possible fight on your hands, because if one party doesn't really want to do it, you can't force people to do something they don't want to do.
Yeah, for sure. And so, like, if we kind of use that to round this out, where there is assets that are jointly owned or independently owned in an existing relationship or coming into one or maybe coming out of one, then people individually and collectively, as in like the couple, should at least consider a private agreement as a way of navigating this at a lower cost with a framework and a structure that has been used thousands and thousands and thousands of times to enable people to navigate this stuff, either if it's already happening or maybe if it could happen in the future. And so I think other people either don't know that this option exists or they go about it the wrong way, to your point. They go straight to a lawyer and say, draft me one of these agreements, not realizing that there is a template and a flow to these. And unless you're in this stuff day in, day out, then you might end up paying tens of thousands of dollars or more to get something that could potentially cost you a lot less than that to achieve the same, if not a better outcome.
Yeah. Look, there are limits to what we can do for the fixed fee. But if you've got somebody with tens of millions of dollars of assets they want to protect, we're not going to be able to do it for $3,500. Like there's going to be a lot more involved in a document where somebody has extensive business interests, multiple companies, family trusts, and all that sort of stuff, right? So, in order to provide the appropriate protection, there needs to be appropriate advice. But for most people, all right, who of a reasonable asset pool, say under $10 million, we can help them. But
okay, understood. I mean, and I think there's a statistic where people misunderstand. There's in property specifically, there is a kind of a confirmation bias that we see where you always hear about the person who has 27 investment properties, but in reality, 95%, I think, of people who own property own either one or two or at max three. It's a very, very small percentage of people who have more than that, and they're massively skewing kind of the mind and the zeitgeist around this stuff. But the vast majority of everyday Australians who are either in a relationship or going into one or coming out of one, if they've got a property, they have one, they might have two, and in a stretch, they might have three. And so being aware of private agreements, knowing that you can utilize these to navigate this stuff better, more effectively, and as if not more equitably, especially if you've got two amicable parties, which hopefully you always do, is clearly kind of where these situate. Any other closing thoughts on this for today, Ian?
If you're going to put an agreement in place, let's say, for argument's sake, you've got a couple getting married, right? And they've got the venue set. They've ordered the caterers. They've got friends coming in from interstate or overseas, whatever. It's going to be a nice shindig, all right? If you are going to put a prenup in place, don't leave it till the last minute. Right. Don't leave it till like a matter of weeks before the wedding, because that leaves the more vulnerable or the weaker party in that negotiation in a position where, well, they might not really have much choice. You know, you don't want to, if you're going to put one of these agreements in place, give yourself plenty of time. Give yourself at least a couple of months prior to the wedding to put the agreement in place, all right, or at least get the legal advice, consider that legal advice, all right, and then, you know, put the agreement in place a reasonable time in before the wedding. Their agreements have been set aside by the courts where they've been made a matter of days before the wedding because it left the weaker party, the weaker, in that particular case, there was a property developer who had assets of like $20 million or so, and his bride who came in from overseas who had virtually nothing. They left the signing of the binding financial agreement or the prenup till like was a matter of a week before the wedding, and that agreement, when they needed to rely upon it, was essentially set aside by the court because the court said that the wife in this case was not in a position to make a decision in her own best interest because all of these plans had already been put in place. All the and if she didn't sign the agreement, or it wasn't, she didn't have any choice in the terms of that agreement, and so it was essentially a case of here, sign this or the wedding's off. And so there you have duress. Duress, unconscionable conduct, and all the elements that the courts need in order to set an agreement aside, because they can be set aside under certain circumstances. And it's like making like building a new house or a building, you've got to make sure you've got the foundations set correctly. If you make the foundations right, you'll have a solid agreement.
Yeah, and so in terms of wrapping that up, so if you've got, if you feeling like this is something that you would want to have in place, doing that in an orderly fashion for both parties, so neither party feels under duress, even if it might be as a shock to one party and they might need time to consider it. The last thing you want to have a solid binding agreement is to have it considered to be under duress. So give yourself and the other party time, do the right thing, basically.
That's right. Yeah. That's exactly right.
Awesome, Ian. Well, thank you for covering all that with us today. That was super, super useful. There's going to be some links in the show to RP Emery Associates. So for people who are thinking this might be of interest to them or want to have a chat about it, then there's going to be plenty of resources you can have a look at and read and inquire further. And hopefully it adds some value. And Ian, thank you so much again for coming on the show today.
Yeah, no problem at all. There's phone numbers on our website. We provide phone numbers because I prefer to talk to people rather than bang emails backwards and forwards. So if you need to have a chat, pick up the phone. Happy to talk.
Wonderful. Thank you.
Okay. Thanks, Vincent.